Kevin.
Rebecca.
Guess what we're doing?
It's a Readathon.
That's right. And we are entering, I think it's safe to say, the final stretch.
Final stretch, yeah.
I don't know if we're going to do a year's more of Readathons, but certainly we only have a couple more for this trial period. So today, Thursday, June 12th, 2025, we had a charging conference in the courtroom. It is the day before closing arguments. You know what a charging conference is?
This is where the parties go over what instructions the juries are going to get. And so it's kind of a wordsmithing and a couple of final arguments about which points of law can be brought up.
That's right. So this is what happened today. Beverly Cannoni made a couple of decisions, none of them surprising, one of them being that Rentschler's PowerPoint won't be allowed into evidence for the jury. I think the PowerPoint itself is less important than probably the impression of him they had at the end.
Yeah.
You know, there was a motion for a required finding of not guilty that was argued by David Yannetti. I should mention Alan Jackson and Elizabeth Little were not in the courtroom today. I'm guessing they're probably working on closing arguments. But, you know, the motion was basically the basis of it wasn't entirely untrue. It was that the crime is a collision and the Commonwealth has not proven a collision.
Okay.
And then guess who got up to argue for the Commonwealth today?
Lally.
Adam Lally.
Where's he been?
Hi, Lally.
He's been at that table the whole time. It was really interesting because while Jackson, you know, did 85% of all the direct and cross-examination, we did see Alessi at some point and, you know, their arguments and stuff. I think Hank Brennan decided I am doing almost all of this.
Right.
And so
Lally did the boring stuff like the technical witnesses.
Yeah, I mean, but those were also small. He wasn't up there for hours and hours at all.
One day he was just reading numbers. That was literally it.
Yeah. I mean, and this is the actual state prosecutor, not the special prosecutor, who basically spent 2 months just sitting there watching a hired gun argue his case for him.
Yeah, literally.
Interesting, yeah.
Literally playing with paper clips some of the time, which I have to say, I do not think Lally was an effective prosecutor in trial one. Obviously, he made a lot of mistakes. He was very sloppy. He's very undynamic. But as you said, he is the employee of the district attorney's office. And he's literally, you can see him at the desk playing with stuff on the desk. And McLaughlin, I guess she's for support. We didn't hear from her at all. But yeah, it's a good point. So I have to say, if I kind of felt nostalgic and nice to hear from Lally today. Hi, Lally.
I got to say, and I think we'll talk about this going down the road, it certainly seems that is one of the reasons why the prosecution seemed to have a little lighter grasp on what the actual evidence is, because there are times where Hank Brennan would misstate things, and sometimes you might say he's doing that on purpose,
yes.
But there are other times where he just seemed to really not understand what was in evidence and what wasn't, and what facts were about certain things. And we saw that a lot during pre-trial motions and the things that he would argue, but the fact that, you know, something like, hey, the holes on the back of the sweatshirt
that wasn't a mistake. That wasn't a mistake. It wasn't.
Okay, how about there were no x-rays of John's arm? I mean, there are things like this. Okay, you say right. You say there wasn't a mistake.
They didn't come in the first trial either. So,
but it also shows that, like, he ought to have known more about those things. And because he said different things, it's out in the blogosphere that that's fact, and it isn't. And, you know, I think that was one of the things where, in the end, that Jackson and his team were just able to let him hang himself.
Right.
And they're going to, you know, the x-rays are a great point.
The flip side of that coin, though, is that he was allowed to do so many things that in a regular courtroom would be considered prosecutorial misconduct. And then he was able to say, oops, I just got here. Sorry. Which, by the way, Bob Alessi in particular was given the opposite instruction during pretrial motions. Like, you say something, it's all of you speaking. You all need to know what the hell is up. So it was interesting and balanced there. He was definitely given more of the benefit of the doubt. So we learned something really interesting about what we are not going to hear in the closing arguments from the defense tomorrow versus what we are going to hear.
Right.
So we heard about this thing throughout the trial called Bowdoin defense. A Bowdoin defense has to do with the competence, the general police investigation, whether or not it was sufficient or not, and whether or not the police, you know, had any funny business. That's very generally speaking. That's not a technical explanation. The Bowdoin defense is kind of by default allowed in this case. Bev says she's going to allow it. The issue is that Bev Cannoni, in an error that a lot of lawyers say is a reversible error, would not let the defense put in a witness that could speak to the competence of the police investigation. Remember that?
Yep.
So she is
the FBI agent who's going to come in and
former FBI agent Michael Easter. So
who probably knows a little bit more about the Karen Read case than just an observer would.
Do you remember at the time why Beverly Cannone said she wasn't allowing Michael Easter to testify?
Because the jurors sort of naturally know what a good police investigation is.
Yes.
And then, Mr. Jackson, would you allow Mr. Brennan to come in and say somebody ran a perfect investigation, and Jackson said, "Bring it." Yeah. Do it, or something like that. Yeah.
Absolutely. So
Did
anyway,
I answer that question?
Naturally, everyone is supposed to know because of these guys, because we've all watched Law and Order growing up, right? That's the same as a court of law argument. Anyway, so the defense is going to make this Bowden argument in their cross-examination, but you know what they're not going to do?
We kept talking about this missing witness or absent witness motion, which was that they were going to be able to tell the jury they could draw an adverse inference from the fact that the prosecution didn't bring a witness or witnesses that they should have.
Right.
Witnesses that were available, witnesses whose absence is not merely tactical, but also witnesses who might present an adverse inference of their case, and they're allowed to do that. Right.
So today, Yannetti withdrew the motion for a missing witness argument. And initially I was surprised, but then he explained why, and it makes so much sense to me. And this is going to get the anti-Karen Read sphere all excited, because they're all going to assume, oh, so we're no longer supposed to believe there was a third-party culprit. We're no longer supposed to believe that Brian Higgins and Brian Albert had anything to do with this. No. What he argued for and successfully was able to argue today was that he is going to bring the third-party culprit defense in through the Bowden argument. So the missing witness thing is no longer important, because the missing witnesses were going to be Albert and Higgins, apparently, right?
Yeah, and probably Proctor.
Well, Proctor is by default kind of allowed as part of the Bowden argument, right?
Yeah.
So they are no longer going to need to do that and have to argue to do it, because what they're going to be able to say instead isn't that, jury, you should think that Brian Albert and Brian Higgins committed this crime. What you should think, jury, this is what they're going to argue instead. The police should have investigated Brian Albert and Brian Higgins. Big difference there.
Right. And it's a lower standard of judicial review in order to get that instruction in, and it's probably a lower bar for jurors to buy. Because I think even Bev said that as far as the third party culprit, right, that she didn't believe that the defense had made that case, and that the prosecution was going to argue that they did argue against that motion, and so by paring it down, it gets it in there, and the jurors will have to grapple with that. And I think one of the reasons why I think that's interesting and smart is because, and this dovetails on what you ended up being asked on Court TV, has to do about, well, what is Karen Read's evidence?
Right.
And which is the improper way of looking at Karen Read does not have to provide any evidence.
Correct.
She doesn't have to prove a whole other theory, although that was a defense that she was going to do. So whether legally or just sort of common sense wise, gets her away from that.
Right.
And gets her back to the thing about, well,
was he hit or wasn't he hit?
Wasn't he hit or wasn't he hit?
Right.
As opposed to, do you believe there was a conspiracy?
Why were they not able to introduce evidence of third-party culprit stuff into this trial? I'm not saying they had to, but why weren't they able to? The answer is Judge Beverly Cannone. She wouldn't let them show pictures of inside the garage. She wouldn't let them present all sorts of things that would have been the bar that they would have had to reach for the third-party culprit defense. She wouldn't let it in. She wouldn't let any of it in. So I think if they had been able to bring some of that in, they probably would have gone further down that road, but that wasn't an option for them. So I think they very smartly pivoted and were like, let's go with fact-based, non-conjectural evidence. And it really helps that they had two witnesses in a row, especially Dr. Rentschler, who hammered home over and over and over again, anything you can't prove is just supposition, and that is not okay. And you know what? In some ways, that's what the third-party culprit defense is. It's not something that's provable because those guys aren't on trial, so they're sticking with the scientific facts. I think it's smart.
Yeah, I think they're playing the cards that they have, right? And unlike in the first trial, you had this parade of witnesses from the McAlbert side. and you had Proctor, and you can confront people, and you had all these Perry Mason moments that got it really big. You weren't going to get that this time.
Correct.
With those witnesses, even if they brought them on.
Right.
They were able to sort of get those facts in, and they're just essentially trying to lower the bar, or actually, I mean, I should say raise the bar for the prosecution, but sort of lower the expectation of what the defense has to present and do in order to raise reasonable doubt.
Right. By the way, there were some Perry Mason moments in this trial, but they were mostly Hank Brennan against his own witnesses. Which was very, very strange. All right. So we had a big conversation today about jury instructions, which I always find super interesting because clearly there's boilerplate instructions that the SJC, which is the Supreme Judicial Court of the Commonwealth of Massachusetts, like sort of says all the guidelines for charges and so forth that the jury needs to receive. Now, both sides in this case wanted the jury to not hear all three prongs of what comprises second-degree murder. There's actually three elements, but they're all like or and or.
Right, there's an A, B, and a C.
Right, so they only wanted them to hear the C.
Right.
And Judge Cannoni said, essentially, I don't know of any precedent for that. I understand you guys agree on it, but I'll have to find a case that says I can do that because the court says I'm supposed to read all three.
Right, because the charge is what it is, and then you have what the law is.
Right.
And so if they want to look at that and interpret the law, not interpret the law different, but apply the facts of the case to a different part of that same law, is that permissible?
Right.
And, I mean, if the jurors certainly could have their own theory of what actually happened, and it could fit in a different place.
That's what makes me uncomfortable. The whole fear I have around this jury is that they might do exactly what folks online do and say, well, if it didn't happen this way, it could have happened this other way.
Well, it's kind of what we heard from the first jury, right?
Exactly.
They were kind of haggling over that second charge about, sort of like what it meant to leave the scene, whether or not she knew. I mean, just
or vehicular manslaughter. Like, what does that mean?
Things are. I mean, it's good that I think that both sides are like, no, we just need to do this one thing. At this point, again, Beverly Cannoni does not want to make an error and have this overturned on appeal, just because, but also because she doesn't want to do this third time.
Right.
I think we know that, right? But that isn't to say that, like, in her own way, she isn't thinking that she's doing everything by the book. She has made a lot of stuff that seemed to be grist for an appeal if it is necessary. But if she's looking for a case somewhere in Massachusetts law, and she can't find it, I mean, I guess I would be. Those two guys ought to get together over lunch and say, let's find a couple of cases.
That's exactly what she told them to do. She said, you guys are probably better at this than I am. Send
me an email.
One thing she is leaving in, which was necessary with the last jury, and I'm not sure it was absorbed, is as an occupation instruction that no juror is more qualified than any other juror because of what they do for a living.
Right. So if someone, if you're a lawyer or someone on, you shouldn't be influenced more by a certain juror.
Like a former cop,
a former lawyer, a politician, whatever, somebody who is a plow driver, right? I mean, these things do come up quite a bit. And so, I mean, I think that's a pretty standard instruction, but, sometimes.
Well, last time it was an issue, as we heard. Both sides agree that the trial prep interview instruction should be there because despite what Hank Brennan has asserted again and again, no negative inferences can be drawn from lawyers doing regular trial prep, aka talking to witnesses before the trial. And I think it's interesting because the defense talked about this quite a bit with Jen McCabe, that she had spoken to the office, 20 times or whatever.
She kept showing up.
She really was
Detective McCabe.
She was a standout in, I think, the parade of witnesses who said they had just gone over prior testimony or whatever. But I think there's a slightly different inference that could be made there, but that's up to the jury. But clearly, Hank Brennan was trying to make a huge deal about this with a ham sandwich yesterday with Dr. Rentschler. You had a ham sandwich after your testimony at the last trial? It's like...
Because they were driving him home, or driving him to the airport, and stopped for lunch.
Why would he ever think he would ever be testifying?
He already
again?
testified.
Exactly.
Yeah.
So anyway, that was really stupid.
Yeah. Was there any instructions to the jurors about how they may use the notes that they've taken and how they can rely on them or not, or others' notes?
I believe they are allowed to use their notes during deliberation. They were allowed to use them last time. I don't think that they're
different
not
states have different rules about that, actually.
Some states
whether
they
you can take notes.
Write the whole time but not use them, which is wild.
Some states they collect the notebooks afterwards, and we have heard that there are certain jurors that are on like their fourth notebook
or fifth notebook,
that they wrote all 2 months,
and one guy who never takes notes.
Which is
wild to me.
But there are 18,
it's
and
true.
Karen Reed only needs one.
That's true. So 1 hour and 15 minutes for arguments will be the allotted time.
Which I think is they're shooting for an hour, but they don't want to get cut off on the last sentence like Lolly did in the first fucking
With his
try.
poor John Adams quote. He just like reached for it. He's like, I only have one thing left to say. Flip, 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 flip. I'm going to quote John Adams now. It was very, very awkward. So here comes the jury form problem.
Oh, which we had in the first trial, right?
Yes. Yannetti proposed what he said would be a clarifying jury form, which was a tiered, like cascaded jury form. So if you decide not guilty on this charge, you would then go to the second charge. If you decide not guilty on the second charge, you would then go to the third charge.
In that order. So don't find guilty on the third charge without considering the first and the second.
Right. The idea being that if this wasn't second degree murder, was it then manslaughter? Or was it then leaving the scene of an accident? She said she's unlikely to grant that particular version of the form. But let's please hope that she actually does what she said she was going to do in the last trial, which is give a not guilty or guilty option for each of the three charges. Because the last jury form just had guilty or not guilty at the top with no indication of what to do with the rest of them.
They raised that issue before, actually I think while the jurors were deliberating, and then that ended up being actually the big problem afterwards.
Yep. Very interesting instruction that also came up was the consciousness of guilt instruction. Now, they played clips of Karen Read in the trial that Hank Brennan can say some of those clips indicate consciousness of her guilt, or the fact that she even gave interviews might indicate. So there is a consciousness of guilt instruction of how much the jury is supposed to weigh that or not. The defense doesn't want it. And Judge Beverly Cannoni said today, are you sure you don't want this instruction? Because there are things in there that are helpful to the defense. You know why I don't think they want it?
Why?
Because I think they want them to think the whole consciousness of guilt thing is bullshit. And if it's codified in the law and there's an instruction about it, then I think it gives it the idea of consciousness of guilt a little more weight. That's just my guess as to why I wouldn't want it. But yeah, so I think he's going to argue that her doing those interviews and things she said in the interviews indicate consciousness of guilt. Does that make sense?
Yep.
All right. Finally today, Alessi argued again. They have made a proposal, a motion for another curative instruction regarding the hoodie incident with the holes in the back of the hoodie.
Yeah.
He spoke to Mr. Lally before and he's like, I'm going to let Mr. Lally argue this. And if he says what he might say, I may not need to argue anymore. Mr. Lally got up and said, we believe what you did was enough. Mistakes happen during trials. So no, we don't want this instruction.
Oh.
Alessi got up.
I thought you would say something better than that. All right.
I think that what Alessi was getting at when he got up and argued was he said, I don't understand why the prosecution wouldn't want this because it's about what happened at being the truth, right? The problem is, in his instruction, he says, Mr. Brennan falsely claimed that XYZ. And I think that's the part they probably most object to.
Yeah.
If Beverly Cannoni agrees to any portion of this, it probably won't include the Hank Brennan falsely did X, Y, or Z, even though I think that's the only inference you can make. And she said, why didn't you object to this testimony at the time? And Alessi did a physical demonstration of why. He said, Mr. Brennan put that giant thing behind the witness stand. We didn't even know it was there. And when he pulled it out and he was showing it to Dr. Wolf, we weren't sure what he was actually showing him until the words had come out of his mouth. And so he actually physically showed the orientation of the defense table versus the witness box.
Yeah.
So anyway, that's what happened. And Lally was like, sorry, it was a mistake. She's going to decide on that later. It's probably going to be a no, as we know. So format for tomorrow. That was the final thing today. They're going to come in at 8:30, be prepared to argue at 9. Arguments will be an hour and 15 minutes for each side. Then she wants to take a short lunch.
Only 30 minutes.
In the courthouse. We'll help you arrange that. Yannetti, by the way, says, my office is 10 minutes away. She said, yeah, but then we might be getting into security issues, whatever. She says, it would not be fair to this jury if they didn't have time to deliberate after lunch.
On a Friday. I agree.
And she's
going to go through all this stuff and then go home and then come back. Yeah.
She's going to, and then she said, I'm going to ask the court officer to contact them and see if they can stay until, gasp, 5 or 5:30.
Oh my goodness gracious. But with Boston traffic? Oh my God, on a Friday?
You have to know.
Are they going to the Cape? Because they'll never get over the Bourne Bridge now.
They have to cancel their ferry reservation.
Get to the Sagamore Bridge. It's not happening. You're not getting on the Cape.
What's interesting about this, and other people might be like surprised to hear this, is that in other places in America, the jury deliberates until they say they're done at night. And it might be 7 o'clock, 8 o'clock, or whenever they're done for the day, right? So in other places, the jury kind of dictates how long they want to go up to a reasonable degree, right? But it would be until the evening. And she's like, I'm going to see if they can stay until 5.
Are you just saying, I'll see if I need to stay until 5 because I need to get to the Cape?
That's right. So full disclosure.
Yeah.
We very well could have a verdict tomorrow. If we did, it would probably be very good news for Karen Read, right?
Yeah.
Let's be real. That being said, I have a commitment that I cannot get out of from approximately 3:30 in the afternoon to 7 o'clock at night. So Kevin and I are going to be devising some sort of plan to instantly make you aware of our reactions to the verdict, but also perhaps so that he can at least do something to make you a little more aware of context. And then, of course, if something happens tomorrow in the afternoon, we will record a robust readathon about it and get it to you as soon as possible.
I think we're going to give, no matter what, rapid response.
Yes.
Rapid response, and then something more in-depth afterwards.
Yes. All right, Kevin. Thus ends, I don't want to call it the penultimate readathon because it's probably not going to be. Thus ends the final stretch readathon. Thank you so much for joining me.
Sure.
Partners in Crime Media.